welcome everyone. We have arrived at the final class of the MBE crash course. I'm very proud of everyone who's been here through the long haul, and just seeing the participants in the room. There's 2 professors and 22 students. This is very impressive. And in the words of Kobe Bryant, the job's not finished, right? We're going to continue after this session, and you all are going to study your hearts out for the next week. And also remember to put yourself in a good mental position to take the test and to perform well. So I'm going to start off by sharing my screen. We're going to do adaptable questions just real quickly. I want to show everyone where they can access the most, I would say, useful materials leading up to the bar. I really believe that this class in a vacuum has been solid. So if you just go to the July MBE crash course, this MBE crash course, I would recommend taking the time to go back through every single subject and go through every single folder. You know, if you go into the materials folder or the video folder, there's everything you need, right? Each folder has tons of notes, outlines, whatever. There's videos for every single subject. We put the questionnaire videos that Matt and I did for the UBE that align perfectly with the federal thing. Can you remind us where the cram guide for the questions we did each Sunday is? Yeah, that's the easiest thing to find right here. If you just go to this materials folder, it's literally right here at the bottom. It's the only material that's outside of the folders. Then everything else is just in its separate folder. We did the condensed outlines. I went over those videos, the last 3 videos, the last 3 sessions, and then the completed questionnaires. These are amazing. These are made by Matt Beckerman, who got a 167. And if you go over each one of these, you know, I wrote the answers out in red, and he wrote all the questions in black, and they're just streamlined for your success. The other thing is that Q&A. If you know, Matt Beckerman wrote these Q&As. It's questions and answers for every single subject that are available in a particular folder. Those will also be online on a digital interactive format by tomorrow or Tuesday. Just as we did for the Florida multiple choice. If you've seen that, we have it set up so that they'll be online. I think that'll be useful because Matt can tell you those questions are not very similar to the MBE questions you'll see. But what I think is important in the last week of study, they do reinforce the very important rules of law, and they come from the mind of Matt. So, you know, you can do the interactive questions if you like. You know, I'm talking about the questions that you made, right?
Yeah, they're pretty, I think they're pretty basic. They're more like for learning.
Yeah, but also for reinforcement. And at the end of the day, in my opinion, the basics is what is going to carry people in the MBE, the low hanging fruit. You got to get all the easy questions right. Some of the hard questions you have no chance at, but you can't afford to get the easy questions wrong. So that's the complete drive. I guess there was no new submissions for album of the year. And I think honestly, there was toss up between the winners. So you'll get an email between what the winner is for album of the year. But we had some really good ones. Remember, exclusive squatter, everyone's getting the adverse possession question right, because it has to be exclusive for adverse possession, not for a prescriptive easement. We had the what is it called, JMOL and renew JMOL. Remember, you can't bring the renew JMOL unless you already brought the first JMOL. We had the marital communications, right? Remember, things that are said in the sanctity of marriage between husband and wife are privileged. There's also the testimonial privilege, where you can refuse to testify against your spouse. We had something about Florida, just make sure everyone's solid on evidence, hearsay evidence. And then I like this one, exceptions to the warrantless search. I remember spaces, stop and frisk, plain view, automobile exception, consent, exigent circumstances, or search incident to arrest. So I know that this might be useless to y'all, but it's interesting to me because the mind and the images associate themselves. And then finally, always associate my rap career with the concept of ill-gotten gains, restitution, quantum merit, quasi-contract, unjust enrichment. See, I'm already telling you my album for the next 2 years. These are all concepts of restitution and when you can disgorge ill-gotten gains. That's the derivation of my name. All right, so I really think you can go through all this stuff and also go through the videos, right? The videos, every single subject we have my lectures from last year. We have the questionnaire videos that Matt and I did. And then for every single subject, we have 2 lectures and a workshop, which is, live questions. If you don't feel good about a subject, I guarantee you, if you just open up the folders and watch all the videos, by the end of that, you'll feel very good about the subject. And like I said, I'm not a hater. Utilize other resources, other people's videos, and just learn everything to the best of your abilities. So without further ado, we're going to start, and we're going to do 25 questions. I know that this software in the final week does slow down a little bit. It's called the algae rhythm. If you ever seen Space Jam 2. So if it just takes a minute to load up, it's just the software. I'm going to start with one poll, and honestly, everyone can vote however they want. Don't worry about offending me. It's literally whatever you want. Let's see if I found it. Oh yeah, literally just vote however you want. I'm in a good mood. You can't ruin my mood. Okay. Choose wisely. So I know that people are free to express on the First Amendment. Pick any business you want. It won't hurt me. Oh, wow. You guys all think Ibis Prep and my little tutoring business is amazing. Thank you all so much. That blesses my heart. That's what I learned to do in life. Control your environment, control your circumstances, right? If you know that something will bother you, don't put yourself in position to be bothered by it, right? So at the bar exam, if you know that listening to other people squabbling is going to bother you, put your headphones in until it's game time. That's what I do. No one's talking to me Tuesday and Wednesday this year because I'm locked in, and make sure you do whatever is necessary to stay locked in. Thank you all for voting for Ibis Prep. All right, let's see. I have to start with the short one. Did everyone know that Arnold from Hey Arnold, his last name is Shortman? Is that true? I think I learned that yesterday, but maybe it was a lie. Helga Pataki and Arnold Shortman. That was in one of my multiple choice questions. I was like, that's his name. All right, let's start with this first one. And what I'll do is I'll load up the first poll and we can get rocking. And if anyone wants to, well, not this poll. If anyone wants to read today or volunteer, I want to hear from everyone. This is my last time to see a lot of you for a while, I bet. All right. A passenger is suing a defendant for injuries suffered in the crash of a small plane, alleging that the defendant had owned the plane and negligently failed to have it properly maintained. The defendant has asserted in defense that he never owned the plane or had any responsibility to maintain it. At trial, the passenger calls a witness to testify that the witness had sold to the defendant a liability insurance policy on the plane. The testimony of the witness is inadmissible because the policy itself is required in the original document rule. Inadmissible because of the rule against proof of insurance, where insurance is not self at issue. Sorry. Admissible to show that the defendant had little motivation to invest money in maintenance of the airplane, and admissible as some evidence of the defendant's ownership or responsibility for the airplane. All right, we have an overwhelming majority here. If everyone can see the result, it's D, right? Because he had a liability insurance, we can use insurance to show ownership or control. Same with like painting the fence. We're not going to use subsequent remedial measures to show that the fence was responsible, broken fence was responsible for the incident, but that you owned or controlled the fence. Anyone out there disagree with D? You sign off on it, Matt? I'm going to ask you every time.
Yeah, I mean, the people who picked B just surely like forgot like the exception.
Right, common exception. And because
The average.
I'm a thorough guy, one thing about me, if I'm gonna do something, I'm gonna do it thoroughly. Let's do a final cram guide piece. And I'm telling you, this is a great thing to read the morning of the test or the night before the test. Why? Because it's all in class. You know there's no mistakes on it because I had 30 people witness me do it. And it's written by me, and I'm very straight to the point, you know. I get right to the point on what it, and I told you guys I was about to say this last week. And I don't know why I'm so, it's been working on that. Okay. Wow, this is a pretty substantial cram guide. Let's call it final review. The day is 7/16. Test is right around the corner, but we should all feel a bit of calmness. If you feel anything on test day, the best feeling you can feel before the test is calmness, right? You want to be amped up and ready, but at some point you want your mind to be calm. Like I expected to be here. I'm exactly where I should be in this moment. Okay, so sorry, we can liability insurance is admissible to show ownership or responsibility, for instance, of a plane. You agree?
Yeah, subsequent remedial measures as well.
Subsequent remedial measures are admissible for ownership or control as well. Hanging the fence. Man, today's our last UBE class too. We did it. Except that one weekend for real property where you had the alleged root canal.
Yeah, that was painful.
I might need to see the best evidence of that root canal.
I think I'm getting the charge soon. My dental insurance didn't even cover all of it.
Well, either will your Ibis prep dental, that's for sure. Okay, I'm just messing with you guys. But no, we definitely don't do dental, if you were asked. All right. A plaintiff who was 20 years old purchased a new high-powered sports car that was marketed with an intended and recognized appeal to youth for drivers. So me, I'm going right to the call to question because it's kind of long. The plaintiff has brought a strict liability action in tort against the manufacturer of the car. You should assume that pure comparative fault applies into this case. If they don't tell you that, we would assume it anyway, right? We would assume pure comparative fault and joint and several liability. A plaintiff who was 20, God bless him, purchased a new high-powered sports car that was marketed with intended and recognized appeal to youth for drivers. The car was designed with the capability of attaining speeds in excess of 100. It was equipped with tires designed and tested only for maximum speed of 85. The owner's manual that came with the car stated that continuous driving over 90 miles per hour requires high-speed capability tires, but the manual did not describe the capability of the tires sold with the car. The plaintiff took the new car out for a spin on a straight, smooth country road where the posted speed limit was 55 miles per hour. Intending to test the car's power, she drove for considerable distance at over 100 miles per hour. While she was doing so, the tread separated from the left rear tire, causing the car to leave the road and hit a tree. The plaintiff sustained severe injuries. The plaintiff has brought strict product liability action in tort against the manufacturer of the car. You should assume that pure comparative fault principles apply to this case. Who will prevail? Will the plaintiff prevail? No, because the plaintiff's driving at excessive speed constitute a misuse of the car. No, because the car is not defective. Yes, because the statement in the manual concerning the tires did not adequately warn of the dangers of high-speed driving on the tires mounted on the car. No, because the plaintiff's driving at a speed in excess of the posted speed limit was negligence per se that was not excusable. Torts, my favorite.
Can you scroll up for a second, please?
Por supuesto. No hay problema para mí. Matt, we did perfect this year on torts, crim law, and evidence. We had minor deviations on the other ones, 1 to 2 points maximum.
I put in a Sun Tzu quote if you want to read it for the recording.
Oh, for sure. Are you trying to get me to read another tongue twister? Are you trying to embarrass me on live TV again? Are you trying to fame me? And it's about my business, so it'd be slander per se.
I feel like Sun Tzu is like the classic business school text.
Yeah, no, that sounds like my alley. I like Sun Tzu. All right, we got 44% participation. Can I get a little bit more?
Yeah, now I forgot what the options were.
Oh my God, you're not even participating?
Andrew, can you scroll down, please?
Of course.
Thank you.
What's up, Rosie? All right, 64%. Last call for. Don't be one of those people at the bar in between day 1 and day 2 on the test. That's not going to bode well. Maybe one drink, you know. All right, most people picked C. I like C. You like C, Matt?
I picked C. I don't know if I like C, but I picked it just because I didn't think anything else really worked. I thought the warning was fine, but I understood what they were going for.
Well, let's see why the warning's not fine. It didn't describe the capability of the tire sold with the car. The tires only went 85. So literally, continuous driving overnight. I mean, yeah, it seems like an inadequate warning. I mean, to me, I was looking for potentially just like, yeah, it's got to be a strict liability. And when it comes to strict liability theories, it could be an inadequate warning, and it could be like an explicit warning, or it can be an applied warranty of merchantability or fitness for a particular purpose, which I think was another claim here. And then, go ahead, Matt.
The fact that it's like appealing to young drivers who don't have a lot of experience means like the warning should be probably better than it is.
And I agree with what you were saying. Like, it's a process of elimination here, right? Like, he was driving it's not a misuse of the car, and you're still liable for foreseeable misuse. And come on, he's a young kid, he's driving fast. Like,
Not necessarily defective, because like they know that, you know, if you want to drive at that speed, it has to have a certain
right,
time.
not
could
per
I-
se effective.
And
Could
it's
I-
per se because it's strict liability. So negligence per se doesn't, like, that imputes negligence automatically. But here, like, you're doing strict liability, so it doesn't matter like reasonability.
Exactly. What's up, Grace?
No, that I liked D, but why wouldn't you pick D? Like what what was your reasoning for not choosing D?
I have an idea.
Liability question, and negligence per se like takes out the reasonability analysis in a negligence question, but this isn't negligence.
Exactly. What were you gonna say, Natalie?
I guess maybe I thought of it wrong, but I kind of thought like negligence per se, it's like whatever the statute is designed to protect. So the speed limit, like her going above it, I don't think was designed to protect anything that had to do with her car.
Right, intended injury design or design.
Part of the speed limit is like not driving so fast that your car explodes on the highway, but here this is like a strict liability issue.
So the car manufacturer created a high-powered sports car and then failed to equip with high-speed capability tires. Yeah, that was pretty dumb. This would make the car unreasonably dangerous, and strict liability may be applied. As in this case, the manufacturer failed to give a proper warning as to the types of tires needed to give to drive at higher speeds. The duty to warn will create strict liability despite the plane's prolonged use of the car at a high speed, because its use at the high speed was a foreseeable use, given its design and marketing. While the car is not defective, the failure to give proper directions and specific warnings was. So we can boil this down into a products liability case arises due to can arise.
Okay, I have a quick question. Why wasn't it not, okay, what made the car not defective? Just because it didn't say the car was defective?
Because it worked. It's just, if you were going to drive it way higher, you need to put different tires on it. There's a lot of things in life like that. Like,
And they should have made it more obvious. Like,
yeah, it's like,
especially like the demographic that they were advertising to, which was like people who have only been driving for a year or two.
Okay, because I feel like if the car can't go to that high amount of speed without the tires messing up, but it can go to that speed, wouldn't that be a defect? But I guess I'm just
defect means
confused.
that it doesn't work for its intended use. It did work for its intended use. You weren't supposed to drive it that fast, but this idiot Chet Hanks boy drove the way past that. So if you only use the car for the reason it was designed and intended, then it was not defective. It worked. It worked fine. It turned on. It went 85 miles per hour. It's just it wasn't supposed to be used that high. But the problem here was there was no warning to let this idiot kid know that it wasn't supposed to be used that high. But it wasn't a defective product. Does that make sense, Chelsea?
Yes, thank you. Well, yeah, but I can see like it could be an argument, a stretch, but yeah, I see.
Maybe a stretch, but yeah, it's pretty clearly, if you use it the way it's supposed to be used, you just drive it at the speed limit, it works fine. It's defective for a foreseeable misuse. And in that case, it turns into a failure to warn. Okay. Proxy liability case can arise due to failure to warn, for example, not properly warning of the need to put special tires in order to drive a car much faster than the speed limit. Right? It's very foreseeable. There's a need for speed.
Exactly.
Exactly.
That's the video game, right? Not the movie.
No, that's Fast and Furious.
Yeah.
There's a need for speed to be fast and furious. That's America at its finest. Okay. And there has to be guns involved too. And really attractive people with little clothing. Okay. A zookeeper filed a breach of contract suit against a seller in federal court in state A, seeking $80,000 in damages. Ooh, I remember this being a tough question, man. I'm gonna need your help on this one if I recall. The seller answered the zookeeper's complaint denying any liability. The seller also raised claim preclusion, as an affirmative defense in her answer because the zookeeper had filed a previous complaint against the seller arising on the same occurrence, which was dismissed without prejudice by the local court. Each party conducted discovery and the case proceeded to trial. Neither the seller nor the seller's attorney appeared at trial. The zookeeper introduced evidence that supported his claim that the seller breached their contract and also submitted evidence supporting consequential damages in the amount of 200,000. For which party is the court likely to enter judgment? The zookeeper for 80, because this is the amount the seller was assumed was at stake when she defaulted. The zookeeper for 200,000, because the zookeeper produced evidence supporting this damages amount. The zookeeper, because the seller, because the zookeeper failed to properly prosecute his case. The seller, because the zookeeper admitted that the federal suit was precluded by failing to reply to the seller's claim preclusion argument. Now, I will say this. I am a man who seeks learning. I admitted at the beginning of class, the one thing I wanted to tighten up, not the one thing, but my top priority was claim preclusion, issue preclusion. If, Matt, this is an opportunity for you to teach these subjects to me, I would love it to occur. But anyway, everyone just take your time and read into it and vote. Participation is waning on this question. 50% participation. You know, at the end of the day, you got to pick an answer, everyone, so you might as well pick. Pick what you would pick if the test was today. I'm the only one who gets to not pick. Oh, wow. 84% participation. 88, 92%, 96%. Everyone participated except me. Oh, 100%. No way. Wow. My heart is so full. Can everyone see the results? No. How about now? Throw back to those Verizon cursors. Can you hear me?
Yes, we can see it now. Yes.
How about now? Good. How about now? If you're too young to know that, you're too young. Okay. Pretty even split. Most people think the zookeeper is going to prevail here. Matt, is there any chance that I could put you on the mic and you could kind of walk us through this question?
Put B, which is what I hope is the answer.
And what was your rationale?
Yeah, so A is just, I know that's A, the zookeeper for 80,000, because this is the amount that the seller assumed was at stake when she defaulted. That's not really the case. Like, you can't just default when it's low and say like, well, oh, even though the damage got much higher, I defaulted when it was low. That kind of gives like kind of like a cost benefit analysis to default, which is not what they want to have. And then C and D, well, C, I don't even know what they're talking about. And D, there's no preclusion issue because it was dismissed without prejudice. You don't have to like, if a defense isn't good, you don't have to, respond to it. So the onus is not on the zookeeper to say, well, there's no prejudice. The onus is on the seller to make a good defense.
So Iona is asking, can you please clarify generally the difference between issue and claim preclusion? Issue preclusion, claim preclusion. Claim would be something like negligence, and a breach of a duty is related to the issue. Is that thinking in the right direction? I mean, I'll give you my basic analysis and then Matt can fill in any details, but issue preclusion is much narrower. Issue preclusion is something that's actually been litigated, like, whether, like you said, whether Tommy was negligent. Claim preclusion is the entire claim. It's not necessarily an element. It's just an issue like that. I guess it kind of is an element of a greater issue, but it could be an issue in itself. I kind of muddled that up. What would you say is the difference, Matt, between issue preclusion and claim preclusion?
So the breach of contract suit, like the whole thing, like this is the claim. And then any issues could be, well, the issue of was it unconscionable? Was there unilateral mistake? Was there impossibility? And if in the first case, like the jury finds, oh, well, there was impossibility against or in favor of the seller, Then if another person brings a suit against the seller could, well, I guess if the person brings it against the seller, actually, the seller could not use it if it's a new person. But if the seller sues someone else and the seller lost in the impossibility analysis, then the person who wasn't in the suit could use it against the seller. I think I'm opening that up also.
That's fine. It's fine. We're getting somewhere. So issue preclusion is we're going to talk about contract claim. The claim is breach of contract, but the issue is the impracticability, and impracticability was ruled no, it was not impracticable. So then in a subsequent case, can you explain the privity and the same party requirement between issue preclusion and claim preclusion? Now that we know what the issue is and what the claim is, the issue is impossibility, the claim is breach of contract. How does that implicate subsequent parties? Do they need to be the same parties in both, or is there a distinction?
I mean, yeah, there's like privity in that, like, if it's like a company was in a lawsuit and 5 years later it's taken over by another company, that new principal company, like the parent company, that would also be bound by the suit as well. Like someone who you buy a home from someone, you're in vertical privity in respect to suits that relate to, the home and the property and the land. So privity, privity applies to both issue preclusion and claim preclusion. It's the same parties or parties in privity. Some states and the federal government also have non-mutual issue preclusion. So claim preclusion always has to be mutual. It has to be the same parties. Issue preclusion, only one party has to be the same, so long as the party that is so long as you're using the issue preclusion defense or offensively against the party that was in the first suit.
Right. And can you just take a step back? What does it mean when you said mutual versus non-mutual?
Yeah, so mutual means both parties have to be the same. Non-mutual means you just need one party to be the same, so long as the party that the collateral estoppel is being used against was in the first suit.
So am I correct in thinking that in claim preclusion, it's the same parties? Issue preclusion, it may or may not be the same parties depending if it's mutual or non-mutual?
Yes.
Cool. That makes me feel smarter. All right. Always remember with claim preclusion, it only applies when judgment has been decided on the merits. That's what Natalie said. And then Amy, I really like what this point is.
So
Claim
long
preclusion is same parties, same sides, and issue preclusion can be used both ways by the same parties. So, and then Hannah has a sheet for mutual, non-mutual that she'll share, she shared with everyone before and she can share again. All right, cool. With all that being said, anyone feel it's not B? I definitely agree with you between A and B, because it's not about what the amount was, it's what you could show. And
yeah.
So if I had to pick between these two, I'd pick B. These questions always make me nervous. Good job. Mad having you on my team helps. Okay. While we're waiting for the algae rhythm, can everyone see my screen, or it just got stopped?
Just got stopped.
Well, there's a solution for that. We're rivers, we go around rocks. I've been saying the wildest quotes this time. It gets wilder every time. I used to show more clips. All right, so this is the sheet that Hannah shared with us. So identical parties for claim preclusion, right? A versus C, first judgment, same action are identical. A versus C's employer, they're privy, identical. A versus C versus A is different because it's a different configuration of the parties. Shout out to the one question we got wrong on Civ Pro. But in contrast, issue preclusion prohibits the relitigation of identical issues that were actually litigated. That's a key piece, and submitted to the trial fact for determination, essential because they were a necessary component of decision in that suit. Collateral estoppel is mutual when it's asserted by parties from the first action, and non-mutual when asserted by non-parties from the first action. In either case, it can be used defensively by a defendant to avoid litigating an issue, or asserted offensively by a plaintiff to establish an issue, but only against a party into the first action. Issue preclusion cannot be asserted against a non-party to the first action, because that would deprive the non-party of his or her right to full and fair litigation. This is illustrated in the following graphic. So issue preclusion, we have A, B, and C. So here are the parties. Mutual, A and C, because they're both the same. Non-mutual, we have one party the same because X is in it. And then here, there's no issue preclusion because C and X
So yeah, because X was not in the first suit, so you can't preclude them from raising any defense or claim.
Exactly.
C was in the first suit, so even though X wasn't in the suit, he or she potentially can preclude them from raising a claim or defense.
Okay, cool.
Potentially, because sometimes they don't allow non-mutual offensive collateral estoppel.
Sorry, yeah. That's my alter ego. My two main email address. I saw this graphic about like what schools drink the most in the country, and it was my undergrad and my graduate school were like top 10. I was just studying in school for sure. So the jurisdiction has the death penalty that applies to felony murder. Consistent with the law and the Constitution, what made the jury may convict the defendant of what? Let me load up a nice poll for everyone, and we'll keep it moving. All right, we'll move swiftly from here and get through these questions. There's definitely, one piece though I wanted to add, which is something for the cram guide. So issue preclusion is narrow, actually litigated.
And like necessary and essential to the judgment, yeah.
Preclusion is broad,
Meaning that
parties.
raise a negligence claim against someone, but it's decided on strict liability grounds, not negligence. The negligence isn't issue precluded from being raised again.
So non-mutual issue preclusion means one party.
Yeah, at least one party is the same.
And mutual issue preclusion means both parties are the same, right?
Yep. But like the configuration is different. Because
Right.
otherwise it'd be claim precluded.
For sure. And then we said defensive issue preclusion is used by defendant.
A defendant who's a new party against a claim by someone who was a party to the first action. But it also could be, I mean, like when you get like counterclaims, like, they can either be like defendants or plaintiffs. But offensive is against a defense, defensive is against a claim.
I've had enough. Like, I swear I've manifested this at the beginning of the administration. I was like, yeah, I can teach everything. The only thing I'm kind of stuck at is issue preclusion, claim preclusion. And I feel like I have talked about it more than anything this administration. But I get it to some point now. For July, I'll be a master of it. All right. Consistent with the law and the Constitution, the jury may convict the defendant of what? A defendant was charged with felony murder because of his involvement in a bank robbery. The evidence at trial disclosed that a friend invited the defendant to go for a ride in his new car, and after a while asked the defendant to drive. As the friend and the defendant drove around town, the friend explained to the defendant that he planned to rob the bank and that he needed the defendant to drive the getaway car. The defendant agreed to drive to the bank and wait outside while the friend went to rob it. Okay. As they approached the bank, the defendant began to regret his agreement to help with the robbery. Once there, the friend got out of the car. As the friend went out of sight inside the bank, the defendant drove away and went home. Inside the bank, the friend killed a bank guard who tried to prevent him from leaving with the money. The friend ran outside, finding that his car and the defendant were gone, ran down an alley. He was apprehended a few blocks away. After finding that they were gone, he ran down the alley. Yeah. The defendant later turned himself in after hearing on the radio that his friend had killed the guard. The jurisdiction is a death penalty that applies to felony murder. Consistent with the law of the Constitution, the jury may convict the defendant. So this is the guy who was with the car. Felony murder imposed the death penalty only. Felony murder, but not impose a death penalty. Bank robbery only, or no crime.
Amy thinks she didn't get a poll.
Who didn't get a poll?
Amy,
No poll for Amy.
I don't know how to.
Right now, do you see it?
No, I just don't have the poll window?
Click polls
Oh,
on the
yes.
bottom. Click polls and it'll come out.
Cool, thank you. I appreciate
You're
that.
welcome.
Natalie, applying for the IT position at Ibis Prep. My friend Jason Lee does it right now. Biscuit. Okay, we have a fair split here. Can everyone see?
Yeah.
All right. It seems that the biggest argument is between B and C. Does anyone want to confidently argue in either way? If not, Matt?
Oh, I can argue for B,
Go ahead.
being that he did agree to it, and he did not do any like of any type of act to fully renounce himself from the crime. And also with under felony murder is for foreseeable crimes that take place during the underlying felony. So that's why I would say that. And I would say not imposing the death penalty because as far as I think I can remember, you cannot give the death penalty to somebody that didn't shoot. So that's why I went with B. Because it was foreseeable and it could happen.
Scarlett, go ahead.
Yeah, I think that Chelsea, you're on the right path, but I don't know if it's shooting. It's more of like if you didn't actually kill the person, I don't think they're allowed to impose the death penalty on you. But I do believe that they are they can hold you liable for felony murder if it was like a co-defendant's act and you were in the commission of committing that crime, a felony, that is.
Yeah, I agree with what Scarlett's saying.
You have to- no, I mean, that's largely correct. You don't have to like explicitly kill the person in order for them to impose the death penalty, but you have to be like involved in the killing or like intend for there to be a killing. Here, the person had no involvement whatsoever. But they can't only impose a death penalty for someone that you like personally killed during a felony murder.
Can anyone explain why it's not only bank robbery?
Isn't it?
Because a person died in the commission of a violent crime.
And it was
Right.
foreseeable that a shooting could be committed. That was the foreseeability part of it.
Yeah, I agree. And no death penalty because they weren't the killer, and felony murder because it was in the act of committing a felony and it was foreseeable. And in this situation, they're going to be guilty for the foreseeable acts of the, let's say, co-conspirators, right? Because they were conspirators at some point. He asked them to drive, he told them what he was going to do, and he agreed, right? So they agreed to do this crime. B, as a basketball? Good job, class. The defendant may be convicted of felony murder because he drove the car to the scene of the crime, knew the friend intended to commit the felony, and dropped him off. This is because the death occurred during the course of and furtherance of the crime as a foreseeable result. However, the death penalty would be disproportionate because he was a minor participant without any intent to take a life and he did not act with reckless indifference for human life. Foreseeable felony murder applies when there is a killing during the course of a violent felony. If the killing is foreseeable from the illegal actions, then accomplice can be convicted of felony murder. In other words, if a death is caused in the course of a conspiracy to commit a felony, all members of the conspiracy are liable for the murder if the death was caused in furtherance of the conspiracy and was a foreseeable consequence. Courts have found most deaths that occur in furtherance of the conspiracy to be foreseeable. The Eighth Amendment, here we go, prohibits the imposition of a penalty that is grossly disproportionate to the seriousness of the offense committed. The death penalty may not be imposed as a punishment for a felony murder upon accomplice who did not take or attempt or intend to take a life or intend that lethal force be employed. So it's, this is the exact verbiage. Did not take or attempt or intend to take a life or intend that lethal force be employed. So take or attempt that, it's pulling the trigger or whatever. However, an accomplice to felony murder may be given death penalty even if he did not kill or intend to kill, if he participated in a major way in the underlying felony that resulted in murder and acted with reckless indifference to human value of human life. So they've kind of stretched it out where you don't even have to be the killer, you just have to be a major participant or the killer. So we can tease out a few rules of law here. Number one is co-conspirators are liable for foreseeable crimes in the furtherance of the plan, let's just say. I mean, this isn't necessarily a conspiracy because, you know, they didn't really
It doesn't matter. It doesn't matter that he changed his mind. Right?
It was
like though with
it was way too late. He already took him to the bank and dropped him off. Like
So
that
if
was,
he
yeah.
reported the crime by stopping him or calling the police, then maybe, depending on like the jurisdiction, that could be considered abandonment. But here, all they did was drive off, which would have stopped him from getting away, but didn't stop him from actually robbing the bank or killing someone.
Right. And then we talked about felony murder occurs during the commission, say killing occurred during the commission of a crime, and then you, well, not you, but a co-felon cannot be liable for, or no, let's say, cannot be sentenced to death, right? If he or she wasn't the killer intending to kill, or at least a major participant in the crime. Does that make sense? Participate in a major way in the crime. They intended to kill. They took the life. One of those things. All right. Let's launch up a poll. More polls, more life. Thank you again, Shelby. You're the one who told me about this polling feature. A farmer injured by machine sued the machine's manufacturer on her behalf and as a representative of a class of individuals injured by the same model machine during the past 5 years. The farmer alleged that the machine was defectively designed and manufactured because the machine failed to shut off when the key was removed from the ignition. Therefore, the machine subjected its users to a risk of bodily injury. The suit was brought in federal court and satisfied the requirements for diversity jurisdiction. The farmer sought compensatory damages both for himself and for the members of the class. He timely filed a request for jury trial on his behalf, on his own behalf, and on behalf of the class. Historically, class actions are devices available exclusively in equity. The farmer requested that the court certify the action to proceed as a class action. In response, the machine manufacturer moved to strike the farmer's jury demand. Is the farmer entitled to a jury trial? Yes, on both the issues of the class certification and the underlying merits of the action against the manufacturer. Yes, but only on the underlying merits of the action against the manufacturer. Yes, but only on the issue of class certification. And no, on neither the class certification issue nor the underlying merits of the action. Let's see. We have a lot of confidence in one answer, but not a lot of participation overall.
Matt, if the case was like triable in law and equity back in the day, and does that mean it's common law and that means you get a jury trial?
Sorry, was that for me?
Yeah. So if you had like a case that was in law and equity back in 1791, does that mean you get a jury trial today for those kind of cases?
For cases in law and equity?
Yeah, that were in law and equity back then.
I think generally cases that were at law.
Like a writ of ejectment, for instance, the answer would be yes, right?
This is kind of a blank area for me that I don't know as well.
Okay.
The answer is yes. There's some things that are just recognized.
That I
And
don't.
one of them that I remember is writs of ejectment. Does anyone else remember anything else that satisfies that you just automatically get a jury?
anything when the Constitution was, right? Like the
Yeah, I mean, if they tell you in the fact pattern that this was triable by jury before 1776 or something, right?
I think it's 1791, which is when they passed like the first Judiciary Act.
Mm-hmm. All right, so we have 83% participation. Let's see. Launch this poll. All right, we have most people picking B. Yes, but only on the underlying merits of the action against the manufacturer, seeming to believe that certifying a class does not deserve jury trial. It says it right here, class actions are devices exclusively in equity. Anyone feel strongly for B or A or C or D?
Yeah, so like this deciding a class certification is a matter for a judge.
I agree.
A jury wouldn't even know what to do with it.
So then, yeah, B.
Why B?
Well, because he was seeking compensatory damages, and damages is a jury, and then I guess class certification is not.
What it means, I don't understand the answer choice of B, like what it means, but only on the underlying merits. What does that mean?
The judge, that means the judge will decide whether there's a class in the first place, but if there is a class, then the jury gets to decide the matter of damages. And like whether there's a legitimate action.
Excellent. You're very good at explaining things, Matt. The farmer's lawsuit against the manufacturer for defective design and manufacture, in which the farmer seeks monetary damages, is an action of law. Since the requirements for class action derive exclusively from equity, the issue regarding whether the requirements for class certification have been met is reserved for a judge, not a jury, exactly as Matt said. Therefore, in this case, a jury could only determine the factual issues bearing on the merits of the action. Can you clarify what the actual question is asking? So the question is saying that there's two matters right here. There's a matter of whether we should certify the class, and then there's the matter of the actual case at hand. And what the question is asking is, who gets to decide those matters? Does the defendant, or defendant, have a right to a jury on both those matters? And the answer is no, only on the underlying merits of the case. And why? Because the underlying merits of the case are for money. And like we talked about, if it's legal in nature, you do get a jury. The certification of a class action is not something legal in nature, which has monetary damages, or as Brighton was saying, was not available for jury trial before, the Constitution. So there's no reason to bring a jury in to hear the issue of class certification. As Matt said, a judge will do that. All right, excellent. We'll go back to the cram guide and just say, there is a federal right to a jury trial for matters at law, which are legal / monetary damages, or certain actions that were available at law before the Constitution. The only one I could think of is writs of ejectment.
I can't think of others off the top of my head.
You can?
I cannot.
Oh, all right, good. I was like, what? It's top of the morning. Let's hear it. All right. Let's see.
Yeah, I can.
You want to read it?
Yeah.
Good.
In a suit by the plaintiff against the defendant to recover damages for the plaintiff's broken leg, the plaintiff will, so this is torts, a plaintiff and a defendant were in the habit of playing practical jokes on each other on their respective birthdays. On the plaintiff's birthday, the defendant sent the plaintiff a cake containing an ingredient he knew that in the past had made the plaintiff very ill. That's a pretty good one. After the plaintiff had eaten the cake, he suffered severe stomach pains and had to be taken to the hospital by ambulance. On the way to the hospital, the paramedic who was driving the ambulance suffered a heart attack, which caused the ambulance to swerve from the road and hit a tree. As a result of the collision, the plaintiff suffered a broken leg. That's a pretty good prank. So will the plaintiff prevail because the defendant knew that the cake would be harmful or offensive to the plaintiff? Not prevail because the paramedic was not negligent? Not prevail because the defendant could not reasonably be expected to foresee injury to the plaintiff's leg? not prevail because a paramedic's heart attack was a superseding cause of the plaintiff's broken leg. So I would not recommend this as a prank to your friends, by the way.
When we get this answer, I'm going to reiterate something I said at the beginning of the class. And I promise you, if you go back and watch the videos, you'll see some of these easy points you forget about. You just want to reinforce them in that final week. So watch our videos, watch other videos, just reinforce. We have 58 participation, mostly all in the same direction. We believe A here, right? Some people, I mean, it was pretty scattered. Everyone picked A because this is pretty messed up, right? But now the question people probably have is, well, the broken leg, that seems very far removed from the, what would we call this? The birthday cake. This reminds me of a crazy story of two people I know in high school. I'll tell it later. But so the broken leg, it seems very far removed from the birthday cake, right? But like I said on the exam, most things are foreseeable. It's foreseeable that if you eat a cake, you get sick, you get in a car, the person driving the car has a heart attack, gets in an accident. You know, there's nothing really to break the chain of foreseeability there, in my opinion. And my approach on the MBE and from my experience is, when in doubt, don't break the chain. You know, only break the chain if you like really can break the chain. So Matt, you agree with us on A here?
Yeah.
Let's see. Superseding versus intervening confuses you. Okay, so superseding will break the chain. Intervening will not break the chain. That's
Right.
about it.
But what's a superseding cause? Like, how is a heart attack not?
Because people get heart attacks. Superseding is just like, you know,
Yeah, I
It's-
honestly said act of God or
yeah, it's got to be really wild or intentional tort. Like, not she's saying this wasn't intentional tort. Yeah, the act of the cake was intentional. There was some battery element to it. Yeah, that's true too. This is battery because it's harmful or offensive. There's a need to be really anything. Yeah.
So it could be said that if I put someone in an ambulance because of someone I did, everything that happens on the way to the hospital, it will be my fault too.
And you know what? I was kind of misspeaking about this. It doesn't even matter about the foreseeability. Amy's totally correct. This is battery. So the minute you sent them the cake, it was a harmful contact. Everything else, and you know what? They're kind of agreeing with you, Natalie, here that, oh, maybe the heart attack was unforeseeable. I'm in the corner of most things are foreseeable. I guess this could technically be a gray area of whether it's foreseeable or not. If this question was presented to me, I would say it's foreseeable that you get in a car and something happens where someone gets injured. But at the same time, Amy's totally correct here. This is just battery. So let's think about it like that. Battery is a dignity tort, right? This is important too. It's not just about getting questions right in this final week. It's about understanding exactly why we got them right. I would have got that right for the wrong reason. I should have known this is battery. Battery is a dignity tort. And offensive touching is all that's required, right? Offensive touching is all that is required. Sending someone a rat poison cake. It's fun now on the menu for today. Sending someone a rat poison cake amounts to battery. And there is no need for a foreseeability analysis, right? Do you understand why it's battery?
A harmful, offensive touch.
An offensive or harmful contact with or without privilege. If actual touching need not be done personally by the defendant as long as the defendant set into motion with the purpose or knowledge to a substantial certainty that the offensive or harmful touching will result. So let's add that in here.
That's also like the prank of a person taking away the chair when someone is about to sit.
Yes, exactly. Or potentially pulling the fire alarm. There's a question where they're like, is it battery, is it not? Who knows? But yeah, if it's likely to happen, right? Generally likely to happen. The offensive touch does not need to be personal, it can be sending the rat poison cake or pulling away the chair. Do they still play that game? Musical chairs, or that's
Yeah, I play it.
Valentina, she still plays it, her friends?
Yeah, she plays it, and I don't know, like family parties and stuff, you know.
Yeah, that's
Yeah,
a
I played it recently.
all right, cool. I think like that and like the piñata, those things will never die. All right. What about the what's the one? The limbo? That was
Oh.
I
Nope.
played that in New Year's with my whole family. It was
I
so
played it
fun.
with on the donkey.
I'm not that flexible going that way. Like I think I would hurt
I don't know
myself.
if that's actually a game because I've never seen it in real life.
After a fire destroyed her home, a plaintiff sued the insurance company that injured the home for the proceeds of her policy. The company claimed that the policy had lapsed. At trial, the plaintiff admits that she failed to make a timely premium payment. However, she cites a policy provision that required the company to give her notice that had not received the premium by a specified date and testified that she never received such notice. The company then calls its chief billing clerk, who is prepared to testify that because of the plaintiff's unusual name, the clerk remembers preparing the plaintiff's notice and placing it in the outbox on his desk, and that an employee from the company's mailroom daily picks up all mail from offices' outboxes and places it in a U.S. mail deposit box. How should the court rule in the admissibility of the billing clerk's testimony? So he remembers preparing the plaintiff's notice and placing it in the outbox on the desk, and that an employee from the company's mailroom daily picks up all mail from offices' outboxes and places it in a U.S. mail deposit box. So admissible only if the company produces corroborative evidence, such as a mailing checklist. It is admissible without more because it's evidence of the routine practices of the business. It is inadmissible because evidence of the mailroom employee's general practices does not prove the particular mailing. It is inadmissible because the billing clerk lacks personal knowledge of the actual mailing. All right, right answers are coming in. All right. We can share the results from this one pretty confidently, I believe. Everyone thinks this one's coming in because it's routine business practice, right? He really does this.
Yeah.
Excellent. Rule 406 permits the use of an organization's routine practice to prove that the organization acted in accordance with the practice on a regular occasion. Large businesses often have standard operating procedures that can be admitted as a habit of an organization. In this case, the clerk followed the standard procedure for mailing out documents. Procedure for receiving and mailing documents is typically a form of habit business evidence as admissible. Therefore, the evidence of admissible is routine practice of business. So we can say that. Ooh, they tried to Mike Pence me over here. Routine practice, routine business practices are admissible. For example, a person can testify about the habits of the mail room people collecting mail. Fair enough. When I teach, I find myself using like phrases that I learned when I was in sales, and I hate myself for it. They always, all salespeople always say that. Fair enough. You want to buy this ridiculously stupid product you don't need? No? Fair enough. How about this one? Fair enough. I should teach a course on the lingo of those people. All right. I'm sure this is going to get everyone more interested in marijuana and cocaine. The colors of the Philadelphia Eagles, green and white. All right. On October 22nd, a police officer submitted an application for a warrant to search a particular address. What are we asking for? Should there granting these motions to suppress? And all right, so motion to suppress. On
The warrant.
what?
Whether- This is based on whether the warrant was correct.
All right, let's check it out. On October 22nd, a police officer submitted an application for a warrant to search a particular address for cocaine. In the application, the officer stated under oath that he believed there was cocaine at the location based of information supplied to him in the morning of October 22nd by an informant. He described the informant as a cocaine user who had previously supplied accurate information concerning the use of cocaine in the community and summarized what the informant had told him as follows. The previous night, October 21st, the informant was in the defendant's house at the particular address. The defendant gave her cocaine. She also saw 3 cellophane bags containing cocaine in his bedroom. The sugar booger. The warrant, that's a joke between me and Stu. The warrant was issued and a search of the address was conducted on October 22nd. The search turned up a quantity of marijuana, but no cocaine. The defendant was arrested and charged with possession of marijuana. The defendant moved to, the student I make the joke with just entered the room. The defendant moved to suppress the use of marijuana as evidence contending that the informant was not in the particular address on October 21st or at any other time. After hearing the evidence, the judge concluded that the statement, the application attributed to the informant was incorrect, and the informant knowingly lied to the police officer. The judge also concluded that the police officer knew the informant was lying. Okay, so Nico, perfect timing. This is the sugar booger question. Based on these conclusions, the judge should grant the motion, and that's a joke. It's a joke about content. Neither one of us do things like that. The judge should grant the motion to suppress because the application contains a material statement that is false, because the false statement, and because no cane was found in the house, because the informant's statement was a deliberate lie, because the police officer knew the statement was false. A lot of answers are coming in. Uniformity. Everyone's picking the same answer. It's never happened before in the history of Ibis Prep that everyone picked the same answer.
I think D, is that what everyone's picking?
What'd you pick?
I think D.
D as in dog?
Yeah.
I agree. And so does a lot of people in the classroom, as a matter of fact. Right, because even if you reasonably rely on a warrant that maybe is factually inaccurate, that's okay. But this wasn't a reasonable reliance on it, right? He knew he was lying.
Exactly. That's like the key part.
That's the key part, right? So even if the information included in a search warrant is incorrect, the evidence seized pursuant to the search warrant will not be excluded from evidence unless there's evidence that the officer knew the information was false. The exclusionary rule is meant to prevent law enforcement officers from acting improperly, but if the officer acted in good faith reliance on the warrant, the evidence will not be suppressed. Thus, because the police officer knew that the warrant contained false information, the motion to suppress will be granted. So this is a great question of like, don't, at this point, we're a week away from the test, don't memorize the question, memorize the applicable rule of law, which is a police officer may reasonably rely on a defective warrant, but may not rely on information he knows is to be false.
Yes.
You like that? How I spun that one, Matt?
Yeah, I think that's right.
When I was in school, I studied a lot of things. One of them was Shakespeare, putting it to use. In order to raise revenue or not to raise revenue, that is the question. No, I actually only took Shakespeare because I had a crush on this girl and she took 1 and 2. So I took 1 and 2 too. And now I memorized hella Shakespeare. All right, in order to raise revenue, a city required home repair contractors who performed work within the city limits to pay a licensing fee to a city agency. A contractor who was unaware of the fee requirement agreed to perform home repairs for a city resident. After the contractor completed the work, the resident discovered that the contractor had not paid the licensing fee and she refused to pay for the repairs, which were otherwise satisfactory. If the contractor sues the resident for breach of contract, how is the court likely to rule? Although the contract violates the law and is void, the court will require the homeowner to pay the contractor the reasonable value of the work accepted. Although the contract violates the law, the court will find that public policy does not bar enforcement of the contract because the purpose of the fee is merely to raise revenue. Because the contract violates the law and is void, the court will not enforce it. Because the purpose of the fee is merely to raise revenue, the court will find that the contract does not violate the law, but will allow the contract to recover its costs only. Oh, your comments are ridiculous. That's definitely a new one. The White Horse Salvation. As a bar prep instructor, I'm trying to learn all the lingo. Sugar booger, White Horse Salvation. When I was a kid, there's a really famous song by Eric Clapton called Cocaine. And my mom told me that it was actually Go Canes, like the Miami Hurricanes. So all my life when I was little, I was like, na-na-na-na-na, Go Canes. But it wasn't the real lyrics. That would be cool if that was a Hurricanes theme song, though. It would be a really perfect harmony. All right. So if we look at the results that we see, a lot of people are picking B. Although the contract violates the law, which it does, the court will find that public policy does not bar enforcement of the contract because the purpose of that fee is merely to raise revenue. Beautiful answer, right?
Yeah, the person just trying to use a loophole.
You're right, exactly. You can't loophole your way out of things in this instance. A contract whose subject matter is illegal may be eligible for defense against enforcement. However, if the determination of illegality comes from whether or not a party has required license, the defense may be limited. If the licensing fee is for the purpose of raising revenue, then the contract is generally enforceable. Conversely, if the fee is for the protection of public welfare, then the contract is void. As the required fee is for raising revenue, it's enforceable. B is correct. If a party is prohibited from doing an act because of its failure to comply with the licensing requirement, any agreement to do the act is unenforceable on the grounds of public policy if the requirement has a regulatory purpose and the interest in the enforcement of the promise is clearly outweighed by the public policy behind the requirement. Here, the regulatory purpose of the licensee was to raise revenue. The licensing required was not created to protect the public welfare. Thus, even though the contractor is prohibited from doing home repair work within the city limits without paying a licensing fee, the contract will still be enforceable because the work was satisfactory and enforcement would not violate the purposes of the licensing requirement. Let me put this in plain speak, what just happened here. Dude comes to my house, right? And he does work on my house, right? And then I find out he doesn't have a licensing fee, or he doesn't have license. Can I not pay him for the work? The answer is no, right? Because he still did the work. And the purpose of the licensing fee is to raise revenue with the state, not to protect me. So,
But if it's like a license saying like, oh, like this person is qualified to do home repair, then maybe not.
right. But doesn't pay licensing fee that is merely to raise revenue. And again, you'll see people like Matt and I, and probably a lot of y'all at this point, we use the exact language they use. Like when I saw that merely to raise revenue, I was like, oh, that's it. Go ahead, Scarlett, what's up?
Matt, I have a question. So you said that if it was like basically the license to certify that he's qualified to do the work, you wouldn't have to pay him. I thought you would still, and he would just, it would be restitution because he completed the work.
Matt, I think she asked you a question. I wasn't.
Oh, sorry, what was your question?
Sorry. Yeah, I asked, sorry. Yeah, I should have just, I didn't realize. So you said that if it was for another licensing, like with regards to the contractor being qualified.
The policy interest behind it.
I'm sorry, you cut out. Can you repeat that?
If it was like a regulatory licensing scheme and there's some public policy purpose, like only having qualified home repairers make home repair, or making sure that like he's up to date on all his tools, then
Oh,
you might void the contract, but they'd still give Quantum Merowit.
There we go. That's the hottest album of the year.
okay, perfect. Amazing. Thank you.
Those would be like lawfully gotten gains. So
Are you still listening to the Quantum Merowit album in your car, Matt? You got that on your
yeah.
Serato right now?
I don't know in DC, but if I did, I would.
A homeowner resides downhill from a metal fabrication facility. She has sued both the owner of the facility and the supplier of the solvent used at the facility. She contends that the contaminants, consisting mostly of the solvent, were released into the ground at the facility and have migrated and continue to migrate to her property, contaminating the soil, the groundwater, and her wealth. She alleges various acts of negligence on the part of the facility owner in causing the release of the contaminants to the ground. She also alleges that the employees of the solvent supplier were negligent in frequently spilling some of the solvent onto the ground while filling a rooftop tank at a facility. The solvent suppliers moved for summary judgment, arguing that there's any contamination, the facility owner and the supplier independently contribute indeterminate amounts to the contamination, and that therefore the homeowner cannot show how much damage each has inflicted on her. There's no evidence that the facility owner and the solvent supplier acted in concert. Should the court grant the summary motion? No, because concurrent tortfeasors are jointly and severally liable for an indivisible injury. No, because the solvent supplier is vicariously liable for damage inflicted by the facility owner. Yes, because there's no basis for allocating damage against the solvent supplier. Yes, because there's no evidence that the facility owner and the solvent supplier acted in concert. Take a minute.
Oh, I didn't get the poll. Oh, never mind. I answered.
This reminds me of the Buffalo Creek disaster. If anyone had Professor Alfieri at University of Miami, it's his favorite book. All right, 56% participation, 60% participation. Everyone's pretty much locked in on the same answer. I like that. Oh, you like that? Yeah, I like that. 14 out of 16, everyone picked A, right? Like, you're not going to get off the hook in this case, right? Like, you did it. They're not vicariously liable. That's not the right answer, but they're on the hook. So I feel like A is the only good answer. You agree with us, Matt?
Yeah, Ace, because this is like a common tort question. Like
Mhm.
you, most of the time, you can't exactly determine who did more of the damage.
Mhm. If we were talking about the UB right now, we're getting a real deep conversation about market share liability. We're not gonna do that right now. Okay. Concurrent tort feasors. It's not too late, by the way, to submit albums for album of the year, and I'll send them in the Telegram. There's a whole lot of opportunities out here, and everyone, they do work. Like, I'll never forget Grace's adverse possession exclusive squad. That always will resonate. You know, the things do work. All right. So concurrent tort feasors are vicariously liable for the damages they cause. Not vicariously liable. Come on, guys. Joint and severally liable.
Yeah, that's why my face went crazy.
Yeah, no, I didn't see your crazy face. Luckily, distinct face. Concurrent tort feasors are joint and severally liable for damages they cause. For instance, if two companies pour chemicals into the water. Just so everyone knows what I was talking about, that market share liability theory, that just means if they're fungible goods, like they're all the same, let's say prescription drugs, and the drugs turn out bad, but there's like 5 manufacturers of it, then you could potentially assign liability based on their market share that they contribute. Like if Merck produces 80% and Pfizer produces 20%, you could assign 80% liability and 20% liability if it's a fungible good, meaning it's all the same, and there's no real way to determine liability. Did I do that justice at all, Brighton?
Yeah, you did.
That's Justice League. All right. Let's launch a new poll and keep it moving. Keep it moving. Ooh, short questions, like Arnold Shortman. A former executive sued a corporation alleging that the corporation fired the executive because of his advanced age. The executive served notice of a deposition for the corporation by serving the corporation's president. The president informed the corporation's counsel that she had no personal knowledge of the executive's employment or termination as a result. Having to appear for deposition places an undue and unnecessary burden on her and the corporation. Is a corporation likely to prevent the depo from occurring? Yes, because the president is not a defendant, was not subpoenaed. Yes, because the president may seek a protective order excusing her from being deposed. No, because the corporation may designate someone else to replace the president as the deponent. No, because as the president, she has knowledge of material facts known to the corporation's employees and agents. An interesting question. I expect some variance in the answer. All right, 60% participation. 72, let's go. Pretty diverse, as I suspected. Anyone feel confident about their answer here?
I do.
Go ahead.
I picked C because this is a deposition of an organization under 30B6. So the corporation can designate someone other than the president to represent them, and then they can prepare that person.
Yeah, I like that. You argue with that, Matt?
I wasn't really sure, but that sounds right. This is a pretty obscure area.
Oh no, we got an answer wrong. My bad.
Well,
Only 2 people picked it, and the president may seek a protective order excusing her from being deposed. It's okay. We're gonna learn together. Matt, were you about to save us there? Potentially?
I picked B, but I'd guessed.
Well, you should have listened to my bad, man.
But I
Um,
couldn't really articulate why I picked B.
No, it's okay. Sometimes you gotta go with your gut. But let's figure it out as a class. The deposition was served on the president, but naming the corporation, I mean, to be honest, only 14% of people got it. 5.6. At least I got it right one time in my life. The deposition was served on the president, but named the corporation as the opponent and contained no reasonable particularity regarding the matters for examination. As such, the corporation's president may seek a protective order on the grounds that this discovery device is being used to harass the adversarial party without a basis for the questioning. C is incorrect. Although the executive served notice of the position of the president, the deposition was for the corporation as an organization as a whole. Therefore, notice had to give particular information regarding matters for the deposition to be enforced. D is incorrect. Even the president who was served, not named only his opponent, does have knowledge of material facts. The deposition notice for the corporation must still describe with reasonable particularity the matters for examination. Let's just tease one thing out. Deposition must contain description of matters to be, what did they say? Matters of examination. And they said, of examination. So this is a very narrow thing, and I don't love narrow questions because they don't really apply that much, but let's just keep this in a narrow bucket. Sorry. Deposition must contain description of matters of examination. If a depot, let's say a vague depot is served on corporation and requires president with no information of matters for examination, and president says she has no personal knowledge of matter, then the correct answer is she may seek a protective order excusing her from being deposed, on the basis that the device is using to harass. Okay, hold on. She may seek a protective order against the depot on the basis that the depot device is being used to harass. So, tough question. I'll take the blame for that. I was very much convinced by the argument. I object to this question for bigness. Yeah, I hear you. But I did get it right once before, so it is my fault. My memory is deceiving me. Okay. A landowner executed an instrument in the proper form of a deed purporting to convey his land to a friend. The landowner handed the instrument to the friend saying, "This is yours, but please do not record it until after I'm dead. Otherwise, it will cause me no end of trouble with my relatives." 2 days later, the landowner asked the friend to return the deed to him because he had decided that he should devise the land to the friend by will rather than by deed. The friend said that he would destroy the deed, and a day or so later falsely told the landowner that the deed had been destroyed. 6 months ago, the landowner, who had never executed a will, died intestate, survived by a daughter's sole heir. The day after the landowner's death, the friend recorded the deed from him. As soon as the daughter discovered this recording and his friend's claim to the land, she brought an appropriate action against the friend to quiet title to the land. For whom should the court hold? The daughter, because of the death of the landowner, deprived the subsequent recording of any effect. The daughter, because the friend was dishonest in reporting that destroyed the deed. The friend, because the deed was delivered to him. The friend, because the deed was recorded by him. Yeah, Matt, we're gonna have to do this whole course over again for February. You got too many questions wrong this time. I think we got like 5 wrong out of like 400. We suck. Shit, you guys all voted for the wrong company when I gave you the opportunity. Matt could have protected us in that last question. He could have given us a protective order for B.
So for this one, oh, I'll wait.
Yeah, that's right. Everyone seems to be pretty locked in, back on track. Guess who's back? Let's see, actually, now it's kind of getting split. All right, we got decent participation. So we're split between B and C mostly. Anyone want to argue for either direction?
I can. For
Good.
C, I chose C because once the delivery is made, it's transferred automatically. And at the moment, he gave complete control of the deed also.
Yeah, I agree with you. What about B? The friend was dishonest in reporting they had destroyed the deed.
You're saying like, why not B?
Yeah.
Okay, because by the time he lied, the deed was already delivered, in my opinion.
Sounds reasonable. Go ahead, Charlotte.
I was gonna say not B because why I was stuck between B and C, I picked C. So the reason why I picked C was I looked at the intent and the delivery portion of it, and when the grantor delivered it and had the intent to convey the land, as soon as it was delivered, like Grace was saying, it was conveyed. Now, like retracting it and all of that, that's like a whole different story. But I think that it's C because it was already conveyed, and the line, I guess, doesn't really allow for the retraction in my brain, at least.
I agree. You agree with us, Matt?
Yeah, it was physically transferred, and the person could have. Yeah,
It's too late. Once it's transferred, it's transferred. So
you can't say here it is, but please don't do it because like the
once
person.
it's transferred, ownership has ceased for the grantor, right? Transfer occurs when there is when there is intent for the deed to leave their control with no exceptions, right? One thing they love to test is like, I give someone the deed, but I tell them if I want it back, give it back to me, right? That hasn't left their control. Oh, and Grace, you've been studying with Andrew Marsh, the new handsome Andrew. There's always a handsome Andrew on my staff. It's never been me, but he's the new handsome Andrew, the old handsome Andrew. He used to teach math for us. It's very handsome. Deed must be delivered to be valid. Delivery is a question of intent. The words of the landowner, this is yours, show necessary intent, strip himself of dominion and control. I like that. And immediately transfer the title. In addition, handing the deed to the friend raises a rebuttal presumption of delivery. Recording the deed is not required to transfer title, and thus the request not to record the document until later is irrelevant. So transfer occurs when there is intent for the deed to leave their control and dominion, like Old Dominion. Any Old Dominion grads in the room? I think this girl went to Old Dominion, ODU. The story I was going to tell earlier about the thing, putting the food, the rat poison in the cake. There was a prank that some really mean bully pulled on this really, I mean, he wasn't the best kid ever, but they put like a Viagra in his drink, and then the cops came. It was like a whole thing. And I just like, this is public school in a nutshell. All right, a consumer bought a kitchen blender for the manufacturer. Soon after the purchase, the consumer was using the blender in an appropriate way. When the blender jar shattered, pull it for everyone. When the blender jar shattered, throwing a piece of glass into the consumer's eye. The consumer brought an action against the manufacturer based solely on strict products liability. The consumer's expert testified that the blender was defectively designed. However, because the blender jar had been destroyed in the accident, the expert could not determine whether the accident had been caused by design defect or manufacturing defect. The manufacturer's expert testified that the blender was not defective. If at the conclusion of evidence, both parties move for directed verdicts, how should the trial judge rule? Direct a verdict for the manufacturer because the consumer's expert was unable to specify the nature of the defect. Direct a verdict for the manufacturer because the consumer's action was brought solely on strict liability theory. Direct a verdict for the consumer because the blender was new when the jar shattered and thus was undeniably defective. Deny both motions and send the case to the jury because the jury reasonably can conclude that the harm was caused by a defect present in the product when it was sold. Got strong answers coming in. Strong answers coming in. Wow. 66. If I can get 2 more votes, we can end it with perfect harmony. What if we all got it wrong? 1 more vote. Perfect. Oh no! At the way end, someone voted. That might have been a joke, but either way, it might have been real. So we don't have perfect harmony. So D versus C. It was undeniably defective. I'm not sure if it was undeniably defective. We seem to have arguments both ways. You agree, Matt?
Matter.
It's a jury matter, right?
Yeah, I'm saying like the newness of the jar doesn't really change it, but this is something that, blenders are not supposed to explode. So
They're
you
not.
take that to a jury. I mean, they're intended to not explode. So the fact that it did explode kind of implies maybe there was a defect there and a jury could find that.
They conclude that the blender was defective at the time of sale because the accident is sort of accident ordinarily occurs as the result of a defect and no other cause identified. They're not required to draw that conclusion. That's usually the best answer when you have all these answers. Like, I'm not saying always, but if you're kind of on the fence, say, send it to the jury. That's literally what we have juries for, is to explain the things. So here's products liability, good piece, intent, negligence, strict liability, implied warranties, express warranties. Commercial supply of a product, producing or selling a defective product, actual and proximate cause, and damages. I like that. It was defective when it left their control for liability to attach. It must also reach the plaintiff without substantial alteration. Generally, privity between the parties is irrelevant, la-di-da. To recover under a strict liability claim, the plaintiff must prove that the defect existed when the product left the defendant's control. Here, a reasonable jury can determine that the blender was defective at the time of the sale because the accident which occurred is a sort of accident that ordinarily occurs as a result of a defect and no other cause is identified, although it's not required to do so. In addition, a reasonable jury could also believe the manufacturer's expert conclusion that the blender was not defective, but again, it would not be required to do so. Therefore, the judge should deny both parties' motion for directed verdict because a reasonable jury could find but is not obligated to believe the other party. So, in a nutshell, and not in a blender, in a nutshell, no directed verdict if reasonable jury could decide either way. For instance, expert attests to a jar shattering that seems to be strict liability. The jury could decide either way. Right? Like it seems like strict liability, but then they did have an expert come in and be like, I don't know. I mean, I get paid the big bucks to say exactly this. So I'm
It's strict liability, but they're still trying to see, like, is there a defect? That's
Right.
what that sure.
Seems to be, yeah, a defect. All right, let's try this one. A contractor, oh, here we go. A citizen of state A sued a man, a citizen of state B in state B state court. The 1-count complaint alleged breach of contract, requesting damages in the amount of $79,000 and demanded a jury trial pursuant to state B rules that provide the right to jury trials and contract disputes. The man argued to the state court judge that the contractor is not entitled to a jury. Is the contractor entitled to a jury trial? No, because the Sixth Amendment right to a jury trial is not applied to the state court breach of contract actions. No, because the Seventh Amendment right to a jury trial does not apply to the states. Yes, because the Sixth Amendment right to a jury trial applies to the state court breach of contract actions. Yes, because state B law provides for jury trials and breach of contract actions. I like this question for a very particular reason. Foot fell asleep.
Yeah, that seems a bit easy.
Suspiciously easy.
Yeah, that was my concern.
Yeah, that's my concern too.
I'm looking, am I missing something?
It's dangerously cheesy. What are you gonna do next Sunday, Matt? Next weekend? You have your Saturday and Sunday afternoon off?
Yeah, maybe I'll go to brunch. That's like a big thing in DC.
Yeah. The liquid brunch is a big thing in Miami.
Yeah.
The liquid and The white horse of salvation lunch.
You say bottomless brunch or liquid brunch?
Both.
Okay.
He does all things in excess with no disregard to the next morning. All right, 62% participation. Not bad, not bad. Most people are picking B, as in they just read it and it said that state B provides the right to jury trials and jury, right? Like it does say that. Do you agree with that, Matt?
Yeah, I picked D because this is a state court. The
Like,
state only guarantees right to a jury trial in criminal cases, which breach of contract is not. And
check it out. And then this would have been the right answer, I thought. I was going to pick B, but then I was like, wait a minute. They did literally say that the rules provided in this contract disputes under this state. So we like D based on reading comprehension.
And it's in state court.
I get this one wrong. I'm going to feel like a dummy for reading comprehension. Okay. So it does not apply to states. Civil juries and state courts are not prohibited. The right to a jury trial in civil cases is a matter of law. Okay. So let's definitely tease that out, right? So
Sixth Amendment criminal, 7 civil, but 7
criminal,
isn't guaranteed in state court.
7th Amendment, civil, 7th Amendment is federal only, but remember, states can enact legislation to guarantee jury trials in certain cases, and if it's a state case, then apply this law, right?
Yeah.
I'm gonna make sure everyone understands the Erie doctrine, the Claxon doctrine. Erie is apply the substantive law of the state in which the federal court is sitting. And then Claxon is one step further, which is apply the choice of law of that state of which the federal law is sitting. So sometimes a choice of law will be like apply the other state law, and then you'd apply the other state law. You gotta just kind of keep going down the rabbit hole. All right, contracts. Speaking of contracts, a contractor. A contractor agreed. Oh, my bad. I'm just so excited to do the question. I forgot that you guys will have to do this polling thing. It's crazy. Our course gets more and more involved every year. You guys got to come back in 5 years. Matt and I will be teaching from like space. A contractor agreed to build a wood frame house for a landowner for $300,000. The parties agreed that the price would increase by the amount that the cost of lumber for the job exceeded the then current cost of $30 per $100 board feet. The landowner reduced the agreement to writing, but inadvertently failed to include in the written contract the pre-escalation clause relating to the cost of lumber. Both parties signed the contract without noticing the omission. When the contractor purchased lumber for the job, the price of the lumber had risen to $60 per 100 board feet. When the contractor submitted a final bill that included the increased price of lumber, the landowner refused to pay the increased price of lumber on the grounds that the pre-escalation clause was missing from the written contract. If the contractor sues the landowner to recover the additional cost, will the contractor be likely to prevail? No, because the contractor's remedy for mistake is avoidance of the contract. No, because the parole evidence will bar introduction of evidence of the pre-escalation clause. Yes, because since the parties were both mistaken as to the content of the writing, the court will reform the writing to express their agreement. Yes, because the contract will be construed against the landowner who drafted it. Have we done any common law questions today, Matt? Constitutional law?
Someone said that the license question was con law, which instead of contracts, which was kind of, I guess, maybe. Well,
I'm just making sure I clicked it when I clicked on the boxes.
you clicked everything.
All right, good. That's something very important. Like, do you know how many students I've known who have passed or failed this MBE exam by 1 or 2 points? So you have to make sure that the answer you pick is the answer you bubble in. I know that sounds obvious, but one little error could make or break you on this test. I'm not trying to, incite fear in people. I'm just telling you the facts that like a lot of people, and I teach for the Series 766, it's the same thing. People pass and fail these professional licensing exams by 1 point all the time. So if that happens to you, don't have that reaction like, oh my God, I'm the first person in history. It's like, no, you're one of the many, many, many people. So like, just be very, very careful that you fill in the right bubble because you don't want to give yourself any detriment. All right, so we got a lot of participation. So I speak Spanish. Since the parties were both mistaken, the court will reform it, right? We're not gonna bar introduction under the parole evidence rule, because remember, this is not the best answer on the test unless it really is contradicting the fully integrated document. If it's adding an additional term, or it's showing a condition to the contract, or it's showing some mistaken information, or it's showing, you know, something extra that doesn't conflict, like this, you know, additional term, I believe it will come in. So yeah, let's reform it. Reformation. When a contract fails to express the actual agreement between both parties due to a mutual mistake, the court may reform it. Blah, 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 blah. So then B, the parole evidence will not bar the evidence of a mistake. So you can put both these in here, right? If both parties are mistaken, reformation is a proper remedy. And parole evidence does not exclude admission of mistake or any defect in information or condition to contract or to clarify ambiguous terms or to add additional terms, just not to conflict the fully integrated contract. Right, that's one of the classic, like, oh, I'm sure everyone knows, that's one of the classic examples of like, you know the parole evidence rule, but they're testing the exception. They really love doing that. They want you to walk it all the way down. They want you to think like a lawyer and take all the appropriate domino steps to get to the correct answer, you know? And if you do that and it's making sense in your head, you're probably doing it correctly, you know? Just think it through, think until you get the answer, pick the answer, move forward. So Matt Beckerman is saying the choice of law is not automatically applied, correct?
No, someone asked a question and I said, I'm not sure.
No, I know. So Chelsea's asking that. So I'm talking about a Claxon analysis. If it is Claxon and you're applying that state's choice of law, it doesn't necessarily apply its home state's law. It might apply another state's law, but if the analysis takes you there to apply choice of law, you'll use the Erie state to apply the Claxon choice of law. All right, speaking of the Constitution.
It was just because I did a question like that, and it was like, you must first decide the choice of law issue, not automatically apply the substantive law of the state in which it sits.
Sure, again, the first thing is it substantive or federal? Like, you don't always apply state law. If it's a substantive issue, you might do federal procedural, if there's a federal procedural law on point. Then if there's not one on point, you have to continue this analysis. All right, let's do this common law question. A senator from state A became upset when he learned that residents of state A are not permitted to bring state law products liability suits against state A companies in state A federal courts, but the residents of state B may do so. The senator plans to introduce legislation that states federal courts shall have jurisdiction when the plaintiff's cause of action shows that it is based upon a state products liability law. Is the proposed legislation constitutional? Yes, because Congress has plenary power to extend federal jurisdiction to any questions arising under federal law of the U.S. Constitution. Yes, because Congress has plenary power to create federal courts and determine the jurisdiction. No, because it would extend federal jurisdiction to state law claims without requiring diversity of citizen amongst the parties. No, because it would not extend federal jurisdiction to defendants who invoke state products liability as a defense. I just got your message too, Barbara. You say you're drinking juice? What kind of juice? Yeah, fresh orange juice. Yeah, for sure. You gotta get that mango juice or that guanabana juice. Did you know I was like 3 years old ago when I learned that guanabana juice and soursop and guanabana are the same fruits?
When you were 3 months old?
No, 3 months ago, years old. I was 33 and a half.
That would have been impressive for a 3-month-old.
No, that would be impressive. I was pretty nice though at 3 months old, if I remember. That's right when Hurricane Andrew hit my house. No, I was like 3 years old when Hurricane Andrew hit my house. All right. Tough question. It's just a weird question.
Yeah, it's about a senator who learns what diversity jurisdiction is and thinks it's stupid, so he tries to get rid of it.
Yes, I was phenomenal. It's the same. All right. So what do we? Oh shoot! Did I show the results?
No,
Not these results. I think it's this one. Yeah, is this what you all picked? Most people picked C, right?
We can't see anything. All we see is the adaptive bar. Oh, there we go. Perfect.
Most people picked C, right? This seems to be the right question. What do you think, Matt? You agree with C?
no, I put B.
You put B. Congress has plenty of power to create federal courts and determine their jurisdiction.
Congress like creates the lower courts. Like the Supreme Court exists on its own, but Congress decides how many Supreme Court justices there are and like what the lower, so the Congress created the lower courts and said they can hear these cases, but they can't hear all state cases, so we're going to limit it in a way that like they won't get overloaded. So diversity jurisdiction is arbitrary, so they can get rid of it if they want to. It's not in the Constitution.
Do you feel strongly about this? Anyone agree with Matt? I probably would have got this wrong. Yeah, this question.
Isn't it a legislator from a state? Oh no, a senator from state A. So he's from Congress.
Mhm.
Okay, oops.
To create federal courts and determine the jurisdiction, right? The appellate courts, they just can't interfere with the original jurisdiction. United States.
This is a federal senator and not like a state senator. Because if it's a state senator, then it would not be constitutional.
That's what I thought, Grace, too, about the senator. I thought it was a state senator, so I didn't think that they had the power to create federal courts. But I do agree with Matt now that he walked us through the logic.
Let's go. Oh man.
Sorry, Matt.
All right.
I guess I was right. I guess it was a state senator, not the.
Hold up. Let me just explain, because I was gonna go C too. If the Senator's proposed legislation were passed, it would allow plaintiff to bring suit and avoid the diversity requirement would be unconstitutional. So the extended to hear a case, a federal court must have both personal and subject matter jurisdiction. Personal jurisdiction refers to the ability of a court to exercise power over a particular defendant or item of property. SMJ means the court has the power to adjudicate. Man, I had gotten this one 3 times right in the past. Yeah, stick to my guns.
Okay, that's my bad.
It's all good, man. Trust me.
I think
As- In the federal courts, there are 2 basic kinds: suits between citizens of diversity states and suits involving a federal question. The party seeking to invoke the jurisdiction of federal court must alternately show that the case is within the jurisdiction. When a case does not raise a federal question, there must be diversity. So at the end of the day, C is correct. SMJ is the court's power to hear certain cases under Article 3 of the Constitution. Federal courts have SMJ over cases that do not involve cases arising under federal law if there's complete diversity. Complete diversity requires that no plaintiffs are from the same state, different defendant. Here, the legislation would be unconstitutional because it would grant federal courts jurisdiction over cases involving no federal question and without diversity between the parties. The language of the statute would permit citizens of the same state to sue each other in federal courts, and that state based solely on a state law claim. In the absence of a federal question, Article 3 requires diversity among parties, typically defined as complete diversity, meaning no plaintiff is a citizen in the same state as any defendant. Blah, 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 blah. All right, so without overthinking this one, because sometimes even the smartest people go too deep in it, Article 3 requires either federal question or diversity, and Congress cannot legislate to circumvent diversity requirement. And I know, Matt, you probably have a really detailed analysis of this and that, but I just want to keep it simple for everyone. Like, you can't circumvent the diversity requirement through legislation. It's okay.
What they could do is they could abolish the lower courts entirely, but I guess they can't change what the lower courts can hear based
Right.
on.
They have the power to amend and modify the appellate jurisdiction of the Supreme Court, but not the original jurisdiction. But of course, not of course, but as we now have confirmed, they can't overstep and circumvent diversity. Okay. A federal agency solicited bids to build a bridge on an interstate highway. In evaluating the bids, the agency took into account the cost of the bridge and other specified factors. A construction company submitted a bid that was lowest in cost, but the agency chose another bidder that offered more advantages on other factors. The company that submitted the lowest bid sued the federal agency in federal court. The only relief that the company sought was to enjoin the issuance of a contract to the prevailing bidder. The company was unable to obtain a temporary restraining order or preliminary injunction. The agency awarded the contract bidder it had originally selected. Just as the new bridge was completed and open, the suit came to trial. Just for speed's sake, we're going to move a little bit faster through these final questions, but do you see what was very clear about this one? Just as it was completed and open, the suit came to trial. How should the court handle this case? Award the company the amount of lost profits, dismiss the suit because it's now moot, dismiss the suit because it turns on discretionary decisions of federal officials, or hear and determine the case on the merits. The class seems to be in total alignment here. And for the first time ever, we have total alignment, right? That this is definitely moot, right? Because the bridge was completed. Once the bridge was completed, there's nothing to sue on. So
B is right, it's just loading.
no,
But
no.
If the company had sued for damages, then it wouldn't have been moot. But because it's only suing for injunctive relief and the bridge is already completed, there's nothing the court could do. It was already over.
The case is now moot and you cannot sue, right? Just remember that last question we got, even when I looked at it, I was like, oh, this is a weird question. You know, as a class, we kind of overthought it, got it wrong. Don't worry, move forward. Each question is an island. For every really hard question, there's a really easy question. I already forgot about Seeing Red. Saw Red as a song by what's your name? The girl from No Doubt, Gwen Stefani and Sublime. Saw Red. We saw Red twice today. All right. A landowner who owned a large tract of land in the mountains sought to protect a herd of wild deer that lived on part of the land. Although the landowner had posted signs that said no hunting, no trespassing, hunters frequently intruded to kill the deer. Recently, the landowner built an 8-foot-high chain-link fence topped by 3 stands of barbed wire across a gully on her land that provided the only access to the area where the deer lived. A wildlife photographer asked the homeowner for permission to enter the land to photograph the deer. Because the landowner felt that any publicity would encourage further intrusions by hunters, she denied the photographer's request. Frustrated, the photographer attempted to climb the fence. He became entangled with the barbed wire and suffered extensive lacerations. The wounds became infected and ultimately caused his death. The photographer's personal representative sued the landowner. Is the personal representative likely to prevail? Yes, because the landowner may not use deadly force to protect her land from intrusion. Yes, because the landowner had no property interest in deer that entitled her force to protect them. No, because the photographer entered the land trespasser's land after the landowner had refused him permission to do so and therefore was a trespasser. No, because the potential harm created by the presence of the barbed wire was apparent. What do we think here? Most people kind of a mix. This is a tough question.
Yeah, so the landowner or the wildlife photographer is a trespasser. The question is just like, what duties do you owe to trespassers? And there is one duty in particular.
All right. Well, we got a lot of participation, but we have variance. Let's see. Anyone feel strongly about their answer?
I
Now
put someone else speak.
You know what?
I put D, but I can let someone else argue for it. Unless there is no one, then I can.
Well, yeah, what were you saying? You were onto something. I wanted to hear what you're getting at. Because you almost led me astray. What were you saying? Because I was picking D too, but then when I heard you talk, I'm like, wait, where are you going with this?
You owe some duties to trespassers, even if they're unforeseen trespassers, which is you can't just set traps for them. Like you can't have landmines or, automatic crossbows or automatic guns, shooting them or like tripwires. But if you have a fence that's barbed, they can tell that it's barbed. Like obviously barbed wire is legal. So you only have a duty to not have like secret artificial dangers. but this is not a secret danger. Like, this is very apparent.
Anyone disagree with D?
Some people did in the poll, but
No, I know, but after that speech. Job. The landowner employed a reasonable use of force, the barbed wire, to defend her property without any attempt to conceal it, which is apparent to the photographer. An average person would stay away from protruding sharp barbed wire covering the top of the fence. However, the photographer disregarded the obvious risk and proceeded anyway, allowing himself to become severely injured. For those who picked A, which is a tempting answer, I think in hindsight, the best thing is like what Matt said. Yeah, barbed wire is clearly legal. You see it all the time. Although this is a true statement, the barbed wire is not deadly force. To be deadly, someone would have to get major parts of their body extensively caught up in a barbed wire. An average person would not have proceeded, especially to such an extent, and thus these photographers assume the risk. So I'm just
camouflaged, I would think that A would be correct.
it's okay to have barbed wire that is apparent around property that people intrude to hunt. Let's try to get through these final questions and call it a day.
So
Definitely not no flake shampoo. I never do that question ever.
6 plus asks the question. If it was deadly force to protect property, it's not allowed. So that's really like if you're in public and I don't know, someone's trying to destroy like your favorite tennis racket that's worth $500, you can't shoot them to stop them. But if someone's on your property, attacking your stuff, it really depends. Like, do you feel like you're in danger?
Yeah. All right. Let's keep it going because I got a busy day, as you guys can all imagine. All right. A worker was injured when a machine he was using on the job malfunctioned. The worker brought a federal diversity action against both the machine's manufacturer and the company responsible for the machine's maintenance. At trial, the worker submitted a proposed jury instruction on negligence. The court did not accept the proposed instruction, instead gave a negligence instruction that the worker's attorney believed was less favorable and legally incorrect. The attorney did not object to the negligence instruction before it was given. The jury returned a verdict for the defendants. The workers moved for a new trial on the ground that the court's negligent instruction was improper. What argument has the best chance of persuading the court to grant the motion? Issues of law can be raised at any time. The court's negligent instruction was incorrect and the worker's objection to it was perceived when he submitted his proposed negligent instruction. The court's negligent instruction was plain error that affected the worker's substantial rights. The need for a formal objection to a judicial proceeding in order to preserve an argument has been eliminated from the federal rules of civil procedure. I'm wondering if Gabby's voting on this one. The court's negligent instruction was incorrect and the worker objected to it as perceived when he submitted. The court's negligent instruction was plain error that affected the worker's substantial rights. What do we think?
So 2 of these answers are just lies. Well, not lies, because like they're doing it for learning purposes, but 2 of these answers are just factually incorrect.
All right. And we don't have too much participation, but most people seem to think C, that it's plain error that affected their substantial rights. You agree with us, Matt?
Yeah, I picked C. A is incorrect and D is just false.
Exactly. And Gabby, we did this question in class too. It's the best objection to incorrect jury errors is that it affected your substantial rights, right?
That's if you fail to object.
The best
Higher if you're saying it was plain error than if you're just saying the judge abused his discretion. But in order to do that, you have to raise the objection at the time.
The parties' substantial rights were plainly affected. All right. Not this one. Not that one either, sorry. There we go. All right. My computer's been through a whole lot. A police department received reliable information that a woman was selling drugs from her apartment. Upon arriving at the apartment, officers noticed the smell of burning marijuana, which is a legal substance in the jurisdiction, coming from inside the closed front door. They knocked on the door and announced police. Immediately, they began to hear sounds of items being moved inside. Concerned that the evidence was being destroyed, the officers opened the unlocked door and entered the apartment, where they saw drugs and cash on the dining room table. They arrested the woman for drug offenses. The woman has moved to suppress the evidence obtained from her apartment, arguing that the police violated the Fourth Amendment when they entered the apartment without a warrant. Should the court grant the woman's motion to suppress? No, because the police had probable cause in exigent circumstances. No, because the police had reasonable suspicion in exigent circumstances. Yes, because the police could have obtained a warrant. Yes, because the police created any exigent circumstances. Results are coming in pretty heavily. People feel confident on this one. Yeah. All right, you guys are all still here. I've noticed that when people don't feel confident, they don't vote, but they're still here. All right. Yeah, this is the classic example of, if they're flushing, they're moving items inside, we have probable cause and exigent circumstances. We agree, Matt?
Yeah. Paul, would you want, so Paul, our resident police officer or former police officer, I don't know if he has any insight into this.
Yeah, I mean, once you smell the weed, you're in, green light.
Whoever smelt it, dealt it. I guess not in this case. But
Once you smell the weed, you have probable cause, and moving sounds inside amounts to exigent circumstances.
You think you're gonna destroy the evidence, or somebody's gonna escape, or you hear some screaming like someone's in danger, you can go in.
Yep. And go ahead, Scarlett.
I was gonna say, because I remember in Crim Pro, my professor going over this in depth, and he was saying you have the knock and announce rule, but like it depends on the size of like the property. So like if it's a small apartment, like very little time has to pass. If you hear some noise, you could just go ahead and enter. But if it's like a larger land, I guess, property, then you have to wait a little bit longer, but it's just to afford like I guess the person inside like decency, like if they're undressed or something. But yeah, automatically, like you hear flushing, you can just enter.
Mm-hmm. Just give me a second for this algae rhythm to work out. I had a feeling this would happen with the way the adaptive bar has been operating. This might be our last question, ladies and gentlemen, for the administration. If I can pull up one more. Just give me 1 second.
Wait, Paul, I'm so sorry. I see that you said that you can get a canine if you're not sure if it's marijuana. Like, isn't that constitute a search if you bring a canine onto the premises? Like,
It's more, I meant it more for automobiles, sorry.
okay, sorry.
Everyone can hear me? Give me 1 second.
Yeah, we hear you fine.
delivery driver backed her truck up. Oh. Did we lose Andrew?
I'm right here. Can you hear me? Matt, are you able to share screen and pull up Adaptabar? We'll do 3 more questions and call it a day.
Anymore.
Okay. Great. Or who in my audience would have it? Anyone can pull up.
I have Adaptabar, but I wanted to ask a question. Because I know that.
I'm sorry, great. Can someone first, just before I want to do questions, I want to get through it. Can someone who has Adaptabar please bring it up? You said you could do it, Scarlett? Here,
Yeah,
I'll give you.
Let me go ahead and open it on my computer.
Does anyone have it open more quicker, maybe?
I just
I
got it open.
All right, you just got it open, Scarlett? All right, let's just
Did you share the?
let's just do a couple questions. I'm trying to give you a thing. Security, share screen. All right, Scarlett, can you please share the Adaptabar questions? And if you have any questions, you can ask them at the end of class. But for everyone's time, let's get through the final 3.
Yeah, give me
Um,
1 second. I'm just trying to open the thing on the Zoom.
It's okay.
Can you guys see my screen?
Yeah, if you just press questions and do 3 questions, all subjects. And we'll call it a day after this.
Is it working?
It's loading. Is it working on your screen?
No, it's just us loading still.
Yes, what happened to me too. This is beauty adaptive bar. Grace, do you have bar max you can log into?
Yeah, let me do it.
All right. Let's give Grace a bar max. And what was your question, Scarlett?
So I was just asking because I saw that Carolina had put that if they if they smelled marijuana but it wasn't marijuana and they find another substance that still could enter of it, like that won't be suppressed, right?
Yeah,
Just because they did had the like
absolutely.
cool.
Absolutely. Yeah. If they smell something that from their opinion is reminiscent of something that is illegal, then that's probable cause. It doesn't have to end up being what they think it is. You're able to pull up the bar max, Grace? All right, let's see. This definitely happens with some of the major programs as we get down to it. It's just so many people trying to use it. The
Can
two
you
questions that
see
we
my
got
screen?
wrong today, if we can recall.
Yeah,
Yeah,
Grace, we
just
could
to
see
remember
it.
the 2 questions we got wrong today. The first question, the reason, well, the second one was the courts cannot circumvent diversity jurisdiction, right? So when the senator wanted to make a law that would allow the federal court to directly hear state law claims without the element of diversity, that wasn't proper. And then the second question that we got wrong, but Matt almost saved us, was about the protective order, where if they are trying to depose the president, but the president is has no personal knowledge and the deposition doesn't have sufficient detail of what's going to be involved, then they don't have any reason to depose the president, and he could therefore seek a protective order, which would prevent him from deposition. All right, let's do these questions. Everyone can see on Grace's screen? Okay, cool. And I think I could still literally pull up the poll feature if I wanted to. Yeah, I can. So I'll pull up the poll, and Grace, do you mind reading to the class?
Yeah. Okay, in 1976, utility constructed a new plant for the generation of electricity. The plant burns lignite, a low-grade fuel which is available in large quantities. Although the plant was constructed in accordance with the best practicable technology, the plant emits substantial quantity of invisible fumes. The only utility can reduce the fumes is by the use of scrubbing equipment sorry, it's just that something is coming up in the screen.
Sorry.
The only way utility can reduce the fumes is by use of scrubbing equipment that would cost 50 million to install and would increase the retail price of generated electricity by 50% while reducing the volume of fumes by only 20%. Because of the expense of such equipment and its relative ineffectiveness, no other generating plants burning the lignite use such equipment. The plant was located in a separately settled rural area, remote from the large city served by utility. Farmer owned a farm adjacent to the plant. He had farmed the land for 40 years and lived on the premises. The prevailing winds carried fumes.
Hey, Grace, just because Grace, can we skip to another one? We're not gonna be able to see it all. It'll be too hard. Just skip to the next one if you don't mind. This is a shorter question because the class isn't gonna be able to read that one. I'll read it too for everyone.
Yeah, please.
No, I know. Can you just try to find a shorter one that kind of fits on the screen? So, because people aren't gonna be able to scroll up and down too much. All right, perfect. All right. Leonard was a high priest of a small cult of Satan worshippers living in New Arcadia. As part of the practice of their religious beliefs, a cat was required to be sacrificed to the glory of Satan after a large live dissection of animals in which it endured frightful pain. In the course of such a religious sacrifice, Leonard was arrested on the complaint of the local humane society and charged under statute punishing cruelty to animals. On appeal, a conviction of Leonard probably will be sustained on the ground that belief in the worship of Satan does not enjoy constitutional protection, sustained on the grounds that the sincere religious belief is not an adequate defense on these facts, overturned on the grounds that the constitutionally guaranteed freedom of religion and its expression was violated, overturned on the grounds that the beliefs of the cult members in the need for the sacrifice might be reasonable and their act was religious. Someone's asking, is there a way you could zoom out? If not, can you scroll back to the question?
Yeah.
All right. Everyone take a minute to look at the question, and then after like 30 seconds, Grace, if you can scroll back down to the answers.
Mhm.
Can you scroll down? Can you scroll down? Yeah. All right, and can you scroll back to the back pattern? All right. Anyone can you see the poll or no?
Yeah, we could see the poll.
Oh yeah, okay. All right, perfect. So the poll is up. I can share the results. Mostly everyone picked B. Does anyone disagree with B? It seems this is Matt. Can you explain the concept here with the sacrifice and in Miami with the donkey and stuff like that?
Yeah, that was, I mean, that was like against the Santeria group, but that statute was actually struck down because they looked back at like the context in which it was made, and it was clearly like discriminatory against the Santeria. Here, this is more of a Division v. Smith thing, where it's just a neutral law that's incidentally applied to a religion.
Exactly. That's the distinction here. And I'll make sure to add this to our cram guide, that a law that is neutrally applied to and affects a religion is valid, but a law that is targeting a religion is invalid. And that's the case. When they said peyote was illegal, the Native American tribe was not able to prevail because it wasn't targeting them. But when they said the sacrificing of animals in Miami was illegal, they did find enough evidence to show that it was actually targeting them. But in this scenario, it doesn't seem to be targeting them in any way about the animal sacrifice. So B is the correct answer. Excellent job. All right, Grace, let's do two more. Okay. Price sued Derek for injuries Price received in an automobile accident. Price claims Derek was negligent in A, exceeding the posted speed limit of 35 miles per hour, failing to keep a lookout, and crossing the center line. Bystander, Price's eyewitness, testified on cross-examination that Derek was wearing a green sweater at the time of the accident. Derek's counsel calls Wilson to testify that Derek's sweater was blue. Wilson's testimony is admissible as substantive evidence of material fact, admissible as bearing on bystander's truthfulness and veracity, inadmissible because there's no bearing on the capacity of bystander to observe, inadmissible because there's extrinsic evidence on a collateral matter. Let me pull the poll up. And if you could scroll back to the question. Everyone can see the poll?
Yes.
Thank you all for bearing with us during this. But it's cool. Like I said, we want to see different resources. These questions are a little bit different.
They're quirkier.
Yeah, a little quirkiness. You know, maybe if you have a study partner who has a different resource, you guys could share resources and get different exposures. We have a very even split right here. 67% participation. One more vote. Perfect. All right. Can everyone see the, can everyone see?
Yep.
I can't really see. So Matt, can you walk us through this one?
Oh, so I can see so yeah, here, he was negligent or claimed to be negligent because, okay, now I forget why he was negligent. I put D because the negligence is about how fast he was going, whether he was actually looking at the road, whether he was crossing the median. The witness is testifying that, oh, he was wearing a green sweater, but he was actually wearing a blue sweater. That's a collateral matter. It's not really getting to the heart. And blue and green are like close enough that it doesn't really bear on the witness's ability to speak. Like if the witness said he was driving a truck instead of a car, or that it was a woman instead of a man, then maybe like you could use that to impeach the witness's credibility here. Here, I think like blue sweater is like so non-material, so unimportant that doesn't at all.
So if I'm writing on the cram guide right here. Is there any rule of law, Matt, that you should tell me to write down on the cram guide?
Yeah, like you can't impeach a witness based on collateral matters, meaning if they get like some small unrelated details wrong, you can't say, oh, it was actually you were next to a 19-story building, not a 20-story building.
Exactly.
But
and then the last one.
Lots of errors, or like the error is like very egregious, even if it's collateral, then sometimes you can bring it in. But here, this is just saying green sweater instead of blue sweater.
Right, and I'm writing the note about the religion is if a law is general and not targeting religion, it is applicable. All right, Grace, if you could pull up one more, and then I can actually probably pull up another adapter bar, we can end in style. So an appropriations act passed by Congress over the president's veto directs that $1 billion shall be spent by the federal government for the development of new military weapon system, which is available only from the Arms Corporation. On the order of the president, the Secretary of Defense refuses to authorize a contract for purchase of the weapon system. The Arms Corporation sues the Secretary of Defense, alleging an unlawful withholding of these federal funds. The strongest constitutional argument for the Arms Corporation is that passage of an appropriation over a veto makes the spending mandatory. Congress's power to appropriate funds includes the power to require that the funds will be spent as directed. The president's independent constitutional powers do not specifically refer to spending. The president's power to withhold such funds is limited to cases where foreign affairs are directly involved. So let me pull up a new poll. Everyone can see the poll?
Yeah, I did forget the answer choices though. But the
What did you guys do? You clicked it without moving forward? Can you hear me, Grace?
Yes. Yeah, I answered it. Sorry.
used to spend the way
Can you hear
that
me?
yeah.
Um, What happened? I missed, what happened? Did we get it right? Did you guys get it right?
Yes, I chose B and it was B.
Okay, Congress's power to appropriate funds includes the power to require that the funds will be spent as directed. Excellent. All right, I'm gonna take back over. That was amazing. Little moment in time. And we'll finish up. I just want to show everyone that I have been updating the cram guide as we've been going. So if a law is general and not targeting a religion, it's applicable. We said that what was the last thing we said? The last question?
That was, if the Congress directs spending, the president and the agencies have to spend it the way that Congress intended for them to spend it. They can't refuse.
Right.
To refuse it by vetoing it and hoping that it doesn't get passed over the veto.
As directed by federal agency. And what was the third question we did?
Well, it's the opposite. Federal agencies must spend money as directed by Congress.
Oh, sure. Federal agencies must spend monies as directed by Congress. We had, if a law is general, not targeting religion, it's applicable. And then what was the other one we did on bar max? The second one?
That was the religion question.
What was the first one?
The religion. The second one was about collateral impeachment. Collateral matter.
Oh, right here. You can impeach a witness based on collateral matters if they get some small detail wrong. Exactly. All right. So today we did 20, and then with Grace we did 3. So that means we do have to do 2 more questions because, you know, we got to finish strong. So let's do 2 more questions, and then we'll call it a final day. Thank you everyone for your patience and rocking with us. All right. Let me load up the next poll. On June 1st, a seller and a buyer contracted in writing for the sale and purchase of the seller's cattle ranch, a large single tract, and to close the transaction on December 1st. The buyer unequivocally repudiated the contract on August 1st. On August 15th, the seller urged the buyer to change her mind and proceed with the scheduled closing on December 1st. On October 1st, having heard nothing from the buyer, the seller sold and conveyed his ranch to a rancher without notice to the buyer. On December 1st, the buyer attempted to close under the June 1st contract, tendering the full purchase price to the seller. The seller rejected the tender. If the buyer sues the ranch for breach of contract, the buyer will probably win because the seller failed to seasonally notify the buyer of any pending sale to the ranch, or win because the seller waived the buyer's August 1st repudiation by urging to retract it on August 15th, lose because the buyer did not retract her repudiation before the seller materially changed her position and reliance thereon by selling the ranch to the rancher, lose because acceptance of the purchase price by the seller was a concurrent condition to the seller's obligation to convey the ranch to the buyer on December 1st.
So this is a classic contracts question. Anticipated repudiation. There actually is a repudiation, but even if you repudiate, you can still perform as long as you haven't breached yet, unless
change their position reasonably.
Like if the other party materially changes their position based on the repudiation. Yeah, and everyone got it right. So
everyone. Right. If the effective repudiation is to deprive the non-repudiating party of a substantial part of the contract, it gives the non-repudiating party the right to terminate the contract and pursue remedies for total breach. The repudiating party, however, is still free to retract the repudiation and reinstate the contract done before the non-repudiating party either materially allows the repudiation or indicate that she considers repudiation to be final. Although the buyer attempted to retract his repudiation on December 1st, his repudiation was not timely because they had already materially relied on it. So,
yeah, but you know that the seller or the other party did not consider it to be final because she said, "Please change your mind." And if the person did change their mind, which they did, but had they changed their mind soon enough, then there would have been a contract. But here, she said, "Please change your mind," but then not having heard anything, she went with someone else. I guess since everybody, I don't know to explain.
Separate. It's too late to cancel the repudiation. All right. And it looks like the final question, assuming we get it right, because we can't enter on a wrong question. Evidence. Maybe Matt Beckman's favorite subject, according to his interview with Ibis Prep.
A plaintiff sued his insurance company for the full loss of the banquet hall by fire. The insurance company defended under a provision of the policy limiting liability to 50% if flammable materials, I lost my place, not essential to the operation of the business were stored on the premises and caused a fire. The insurance company called the keeper of the city fire inspection records to identify a report prepared and filed by the fire marshal as required by law, indicating that shortly before the fire marshal had cited the plaintiff for storing gasoline at the banquet hall. This gives me public record vibes.
All right, well, thanks for giving her the answer, because I agree. Definitely public record vibes, right? We're
Yep.
feeling public record vibes here. And honestly, I just don't feel like this was the right question to end on. It was given public record vibes. We felt public record vibes. It was too easy. I don't even have anything to write down. Look, I've gotten that question right 5 times. Not ending that easy. No, we move on for one final question. So if you remember one thing about Ibis Prep, one more question. We always dig deeper. You know, when you think you're done, you keep pushing. You reach the finish line, you keep on going. So finally, go ahead. In a civil action for breach of an oral contract, we must first pull up the poll, a brand new poll. All right. In a civil action for breach of an oral contract, the defendant denied having entered into a contract with the plaintiff, although he admitted that he had discussed doing so. Which of the following standards of admissibility should the court apply to evidence proffered as relevant to prove whether a contract was formed? Whether a reasonable juror would find the evidence determinative of whether the contract was or was not formed, whether evidence has any tendency to make the fact of contract formation more or less probable than without the evidence, whether evidence is sufficient to prove, absent contrary evidence, that the contract was or was not formed, and whether the evidence makes it more likely than not that a contract was or was not formed. Matt, I know you know this one. I know you know that you know this one. Let's let the class do it. Okay, class is doing good. A lot of results are coming in. This is just the rule of evidence. How is something going to be relevant? How is it going to be relevant? And as the class is overwhelmingly deciding, if I can get 2 more votes to make me hit that 72 mark. As the class is overwhelmingly deciding, the answer is B, right? If it has any tendency to make the fact of contract more or less probable than without the evidence. That's if it's relevant. If it has any tendency. You agree with us, Matt?
Yeah, of course. This is like the relevancy test.
This is the relevancy test. So we could see, like I said, we did amazing today. 25 questions. We had gotten 2 of them wrong. But the 2 that we got wrong were good learning questions. We learned from the first one about there was the president, and basically the president was able to get a protective order not to speak because really she had nothing to do with the whole situation. That was that one. And then our savior, our strong leader, Matt, led us down to the fire pits when we weren't considering the diversity of citizen requirement, right? That even though the Congress does have power to amend and modify the appellate jurisdiction, anything that's not, the Supreme Court original jurisdiction, they still have to be careful not to overstep Article 3 and circumvent subject matter jurisdiction. So really amazing job with the material. It pains me for us to say, and yeah, Iona, you said you had a great last question, or is anyone, I'm sorry, Danielle said the standard of relevancy, please. So for something to be relevant, it just has to have any tendency to prove that something was more or less likely probable to happen. Remember, when we're talking about standard, it's like standard of guilt in a criminal case is beyond a reasonable doubt, the Jay-Z album. Standard of liability in a civil case is preponderance of evidence, more likely true than not. What we're talking about is just the standard to bring something in and let the jury consider if it's, evidence, if it's relevant. And that's a very lesson standard for relevance. It just has to have any tendency to prove that something is more or less likely probable than without it. Matt, I got to ask you, because this is the end of a great course and you were the bomb.com for this entire thing. You probably have scored the highest on the MBE of anyone I've ever known. What final advice do you have for test takers, with 8 days to go, let's say 8 or 9 days to go?
Yeah, get sleep, exercise, eat well. Make sure you know where very important, make sure you know where the bathroom is in your test area. And yeah, like know what you're doing, like don't spend any time like looking at the instructions. You should know like what to do on the MBE, on what to do on the essays. Also, yeah, definitely like get sleep, don't freak out, spend the day before kind of relaxing.
Awesome, man. And for me, like I said, this last week, it could be a week where you're just tying up loose ends, or it could be a week where you're starting fresh on every single subject and going from the beginning to the end to make sure you really got this material down. Really thank you all so much. Grace is saying, don't eat anything crazy the night before. Just do what you've always done. You've got this far in life. You deserve to be sitting here taking this test. And if you believe in yourself and you finish the job, I believe you're all going to pass. Thank you all so much. It's been an absolute pleasure. Matt, you've been amazing. All my students have been amazing.